So the question comes up of do I need a will? The answer is yes. If you are a person and you own property and you're living, it's a good idea for you to have a will. If you don't write a will, the state of Texas is going to write a will for you. So your property may not go to those people that you want it to go to. This is often the case, especially with folks that have remarried and have children from a previous marriage. If you don't say everything goes to your wife, then your children from a previous marriage will have an interest in your home, which can cause all kinds of headaches. So there are other documents that we put into an estate plan that we recommend. A statutory power of attorney, a medical power of attorney, a directive to physician, a declaration of guardian in the event of incapacity, a HIP release. What all these are designed to do is to cover all of the contingencies. Whether you're just injured, you're in the hospital for a while, or if you're on your deathbed and your family doesn't know what your wishes are, you have a document that says what your final wishes are. So oftentimes when people ask me about wills, they say, how do we avoid probate? I don't want to go into probate. It's expensive. Well, yes and no. It can be, but you shouldn't, at least in Texas. If you have a will, probate's fairly easy. What is difficult is when there is not a will and it becomes a mother may I with the court, and it gets very expensive. That determination of whether the will needs to be filed under probate is really not something that can be determined until after the person passes, because scenarios change, situations change, and sometimes people deed over stuff, sign over things prior to the death that do not necessitate the will being entered for probate. But that's a determination that needs to be made on a case-by-case basis. So oftentimes we get people that have already started a business, and I ask them what kind of entity you have, and they say, I have an assumed name certificate. Well, that's not an entity, that's just you as a sole proprietor. And I think that's a misunderstanding because they think that they filed something with the state or with the county, but there is no liability shield there. So the number one entity we recommend is a limited liability company. That provides a liability shield, so if you run into something in your personal life where a judgment's against you, they can't come after the assets of your business. Also, if you're dealing with your business, if you're in a contract and there's a breach of contract situation, they sue the LLC and they don't typically sue you individually. So sometimes folks ask when they're forming an LLC, is the additional cost of a company agreement worth it? A company agreement is an agreement between the members of the LLC, and it covers what happens when things go bad. It can also cover things that are a little more out of the ordinary. For example, we represent a lot of inventors, so you can put things into company agreements like rights of first refusal, to where if somebody comes with an idea, they can present it to the LLC. The LLC decides that they don't want to pursue that, then the person is free to go on and seek other support for that. But those are the kinds of things that need to be on the front end of an agreement before people start making money, because it's a lot easier to agree on things with a document signed than later when everybody's making money, but then something goes wrong and then they're left to the court to make it up, and that's always more expensive than agreeing to something on the front end of the deal. And sometimes we get folks that we didn't form their LLC for come in and they're wanting some kind of document drafted. And the question comes up is, well, why can't I just do this? It seems simple. And why should I pay an attorney to do it? Well, we see the tail end of that when they when they make that decision to do that, is where they get into trouble. For example, they fail to name their own entity in their document, so they end up entering into that document in their individual capacity, and now they're on the hook for whatever goes wrong. So the investment up front of having an attorney who's experienced drafting these, that knows the legal things that are going to matter down the road, that you may know the general terms of what you want out of a deal, but you may not know how those are going to affect you in court. And that's why it's good to pay your attorney up front.